Good afternoon, everyone. Thank you very much for coming this afternoon. It's a pleasure to see all the familiar faces and then all the new faces here too. We appreciate it. My name is Joanne DiPietro. I'm an attorney in Walpole, and I have David Yo with me today. David is an attorney in my office, and David has been involved in real estate since 2018 and an attorney since 2023. He is extremely proficient in estate planning, probate administration, trust administration, and mass health. All that stuff that you want to know, David's got in his head. So we're going to have some great questions and conversations later on. Most of you know who I am. I've been practicing law for 28 years now. Holy cow. And I've been in this area since then. Our office is right on Main Street, so we're always available for questions. So today is our annual Wills and Trust review. What does that mean? That means I want questions. I want you to participate. I want you, if you have questions, to ask those questions, because your neighbor sitting next to you may have a question similar but may not know how to articulate it. And those conversations is where we really learn from each other. Okay, so let's start with the foundation of an estate plan. Foundation of an estate plan, I kind of made that up. It's not a legal term, but is your will. And what you need to remember is all of these documents that we're creating is so that you can be heard. So that you can be heard whether there's death or there's incapacity. Everyone knows these days, because of fraud and everything that's going on, you have to have permission an authorization in order to speak for someone else. So these written documents are in black and white. Remember, attorneys don't like gray. We like everything black and white, is so that people can responsibly speak for you. I use the word responsibly because you're giving them direction. You want to be able to, we've heard speak from the crypt, whatever you want to call it, but you are telling them exactly what you want. But not only by putting that in writing and telling them what you want, you're also protecting them if someone is telling your fiduciary that you appointed that, no, it should really be this. So you're protecting yourself and you're also protecting the person that you're appointing. So let's talk about that fiduciary appointment within your will. It's called a personal representative. Many people remember it being an executor or executrix. It's the same exact role. They just heightened up the name a little. I actually like it better because it's a person that's representing the decedent. Makes sense. That person gets appointed by what's called the probate court. We're going to put probate over here for a second. We're going to talk about it in a little bit. Your will then tells us who your family is. Why are we concerned about who your family is? Because if you die without a will, then all of your assets when you die go through the laws of intestacy. That means your blood relatives, okay? And if you're going to change a distribution as to where your assets are going to go, again, we want it in writing. And that's where our will is the foundation for us to look to see what you wanted. The other things that are listed within your will is tangible properties. Tangible properties is everything you can see, feel, and touch. Your jewelry, your car, your furniture, anything else that you can touch and move. A house, a bank account, those are intangibles because you can't pick those up and take those with you, okay? So the will handles the intangible items. Then your will is going to state, I give all of my interests to Mary Jones when I die. And then it's going to say, well, if Mary doesn't live past me, then I'm going to give it all to David. So as you can see, as I'm speaking, I am telling you what the terms of my will are. So when I'm gone, someone else can move forward with that. How does a personal representative get appointed? We take that original will to the probate court. We're in Walpole, so I'm going to use Norfolk Probate Court as an example. And we ask for that will to be proven and allowed. That means it gets stamped by the judge. We have some procedural work to do for that. But once that gets stamped by the judge, and I've appointed David as my personal representative, David can now speak for me through the criteria that I put within my will. Okay? Does that make sense? Okay, if I ever wanted to make a revision to a will, let's say David doesn't want to perform his duty as a personal representative, and I'm going to have Linda Winslow be my next personal representative, I would create what's called a codicil. So a codicil is an amendment to a will, but it's called a codicil, okay? So the next document I want to talk about is trust. This is the big one, right? Everybody wants to know about trust. If you look at the handout on the back page, this is the Cliff Notes version. Let's say that, if everybody remembers what Cliff Notes are. Summary of trust. Today we're going to talk about two different types of trust. They're the most common trust that we all can see on a day-to-day basis. The first one is a revocable trust. Revocable, exactly what revocable means. You can change it, you can amend it, you can do anything you want with it. So when you think of a revocable trust, think of the revocable trust as a two-layer system. I'm visual, I like using visuals as an example. This is the document. This is the document, the written document where you are the trustee once you sign, seal, and deliver it. What does that mean? It gets dated, it gets witnessed and notarized. Once that is created, you have become the trustee of that trust. Then what happens, this bottom layer is the equitable interest of any assets you move into this trust. Perhaps you move a home into this trust, okay? And I'm going to relate that back to probate in 2 seconds. You move the home into the trust. The trust is now the owner of the property. You are the fiduciary of the trust. You're the appointed person to speak for the trust, okay? And while you're alive and while you have your capacity and you have the ability to understand and make decisions, you will remain as the trustee. The trust is also going to tell us who the successor trustee is in the event you're unable to perform your duties, okay? So what we've done here is we've created a document where you will be heard upon death or incapacity. Now, why is this different than a will? It's different than a will because this trust is effective as of the date that it is created. A will is effective as of the date it's created, but we need to take the will to probate court in order to have that personal representative proven and allowed and get them appointed. I love trusts. I'd rather do a trust administration than a probate administration. It's easier for my clients. It's easier for us to contain all the assets and have them run through the trust. By way of example, David and his wife own a home, and that home is owned husband and wife, tenants by the entirety. Tenants by the entirety has what's called rights of survivorship. If David were to predecease his wife, his undivided 50% interest immediately goes over to his wife, which is great because we've avoided probate. We've avoided probate because a probate asset is an asset that has nowhere to go when someone dies. You own it individually as of your date of death. Probate court is the court in our jurisdiction that has jurisdiction over dead people's things that have nowhere to go, dead people's things that were held individually. Why are we doing all this? We're trying to make it easier for the people that we're leaving behind. So the best thing to do is to either have a joint tenancy or to put it into the trust. Now, going back to the home between David and his wife, upon David's death, his interest went to his wife, but then we created a probate asset. So now, should his wife die before she moves it into a trust, that home will have to go through probate. Probate court, their job is to make sure it goes to the heirs at law. Remember at the beginning we talked about within your will, you tell us who your heirs at law are. If you don't have a will, then it goes by the statutory law, okay? Any questions on that?
What do you mean by a statutory law if you don't have a will?
So what happens is if you have a probate asset, you own it individually, people need to know where it goes. If you haven't designated during your lifetime that you want it joint, that I want my bank account that's held joint with David to go to David, then it goes through court. And then if I don't have a will and I haven't stated within my will who I want that bank account to go to, then it goes by the laws of intestacy, which means your heirs at law, your bloodline. Okay? So when, this is what we learned in law school, the tree, what you look at is I'm the decedent. If I have a husband, it goes to my husband or spouse. If there's no spouse there, it goes down to my children. If there's no children there, it goes up to my parents. If there's no parents there, it goes out to my siblings. So the thought process is, where do you really want that account to go when you die? Who do you want to inherit those funds? So this whole thing is a process. A lot of you, I say, have been tortured by our estate planning questionnaires. But what it is we need to know everything that's going on so that we can wrap our arms around your assets to make a determination as to how best do we retitle or move in order to meet your goals. This whole conversation is about what are your goals and thinking about what your goals are. And sometimes by the time you're finished talking to me, your goals may have changed, only because I would never want my parents to inherit money from me because they don't need it, and maybe they might be going into a nursing home, and the money would only go to a nursing home. So we ask you a lot of questions so that we can help you work through those goals, and then we explain to you what documents we're going to use. Remember the black and white, everything has to be in writing. What documents will help you to achieve those goals? Make sense? So one thing that I didn't say at the beginning, I'm going to come to you and give you the microphone because we are being recorded today.
You said that if we don't have a will, it will go to the court, but that would be unless there is no trust, correct?
Let's back up a little. You go to probate court if you own an asset in your individual name because it has nowhere to go. Pardon?
You said in Tennessee?
Tenants by the entirety, which means rights of survivorship. When there's a survivorship, then the asset goes to the joint tenant. If Mary and I own a home together and I pass before Mary, my interest in the home immediately goes to Mary.
The court does not need to approve that.
That is correct, because it has been contractually set up outside of the court. But now Mary owns the whole home when she passes. So where does that go? If Mary has a will, it tells us who it will go to. If Mary doesn't have a will, then it goes to her heirs at law.
But what if she has a trust?
Okay, so that's hypothetical A. It's not in a trust. Hypothetical B, we own a home together that is in a trust. I pass, and there's a presumption that the home goes to Mary. My interest goes to Mary upon my date of death. Because the home is in a trust and it's owned by the trustee or successor trustee of the trust, when Mary passes, that house stays within the trust, and then the distribution is set forth within your trust. Without the need for probate court. Got it? Thank you. Did I see a hand go up? No. So it's complicated. But once you can always remember, individual, you end up in court. The asset's owned individual. So we want to try to avoid court. It's a lot of work. You know, I'm not going to lie. It's a lot of work. But we can help to guide you, or your own attorneys that you're using now can help to guide you in order to make a determination as to the asset. Can it contractually go somewhere else, or should it be within a trust? Okay?
If it goes to court and if you don't have a will, does the court take a percentage of his big fees or anything?
No, the court doesn't take, no, there's no There's no penalty for not having a will. No, it's the laws under Massachusetts that tells us where a decedent's assets will go. There's administration fees, yes. You could do the administration fees your own, or I would suggest using an attorney because it's a complicated process. But no, there's no penalty for not having a will. The state doesn't take anything just because of probate. That's correct. Yep. Any other questions on the revocable trust? Thanks, David. David's going to come to you so you can tell us all your question.
My question is, if there is a will, there are trusts, maybe land trust or whatever within, if a document might be found that gives direction, a document, say the will was found and everything seemed to be in order, and there was an additional document that was signed by the person or persons that had passed away, but it was not part of the original will. Mm-hmm. How would that be addressed, or even would it be addressed at all as part of the legal formation?
That's a great question. That's a great question. So the documents that we've spoke of so far, the will and the revocable trust, both of those documents can be amended. Do they need to be amended in a certain fashion? Yes. You know, you hear the cocktail napkin. I'm going to give you my car, and here's my little contract, and I'm writing it at, Raven's Nest. Is that a valid contract? Is that valid to make sure that someone's going to get that car? The answer to that is no, because there's no witnesses and there's no notary, okay? So notary is not a statutory requirement. What does statutory mean? We get laws by different ways. We get statutory Massachusetts general laws. We get laws by case law. When judges make certain rulings over and over again, they set what's called precedents. A codicil to a will does not need to be notarized. We like it notarized because then we know it's someone's free act and deed, willingly and voluntarily, that they're doing this without duress, and that they have capacity, both that they're over the age of 18 and that they have mental capacity and they know what they're doing. But there is a statutory law requirement for wills of 2 disinterested witnesses. So I'm going to tell you to make sure you go back and look at your documents and see if you need any updating. But you're going to see that there's 2 disinterested witnesses who stated that it was your free act and deed and so on and so forth. So let's say my estate is being probated and my daughter finds a letter that I wrote and it changes what my will originally says. That technically is not going to be submitted to the probate court because it wasn't drafted and signed in a statutory manner. So those are kind of the rules of what we need to do. Does that make sense? Yeah.
Thanks. So I had a question. You said that the inheritance and so forth goes through the bloodline. Is there a way to set aside certain funds, say for, a grandchild for college tuition or something, that would go to that child directly rather than through the parent?
Outside of the will? Yeah. Great question. One of the products that's available is called a 529 plan. And, I'm just going to use Fidelity because they're prominent in that area. Fidelity Investments has that product. And what you do is you set up that product, a 529 plan. You would actually be the trustee of it, and the beneficiary is your grandchild. And a lot of people will use that as a way of gifting We've heard about gifting. A lot of people will use that as a way of gifting, but the child can't access that money. And so long as that money is paid directly to an educational institution, and that's broadened. It used to just be college, and now I believe it's even a private elementary school. And trade schools, it's grown to that as well, which is fabulous. As long as it's paid directly, then there isn't going to be any taxable event on the income that is accumulated. Okay, so that's leaving something to someone by a contractual relationship outside of the will. And it's a fabulous idea. Yes.
What if the child chooses not to go to college? What happens to that money?
So what you can do is you can change the beneficiary. If there's a sibling of that child or another grandchild that perhaps is going to go to medical school, graduate school, that money can be changed, or rather the account can be changed with the beneficiary, and that money can be used for that person. If there's no longer any grandchildren to use that money for and you pull it out, then that's a taxable event. Let me grab a question here.
So I've heard two different answers. And the question is, you own a home, you're getting on in your years. Oh my God, what if I have to go to a nursing home? They're going to take my house. So I go to a lawyer and they say, oh, you have to put it in a trust to protect the house. Okay, but then I go to another lawyer and they say, you don't need to put it in a trust. So my question is, why would I not put it in a trust? And what are the benefits for not putting it in a trust? And why, then again, should I put it in a trust?
Most people think I planted her to say that question, because that is now our segue into irrevocable trusts. Let's just tie up revocable for a second. Remember we talked about the two-layer system, that this is the equitable interest. If you put that home into this type of trust, a nursing home is a creditor, okay? If you have dominion and control over an asset, you can sell this property, you can rent it, you can mortgage it, you can do anything you want with it. It's yours, right? Guess what? It's subject to creditors, including a nursing home. That's a revocable trust. Why? What's the primary reason to use a revocable trust is to avoid probate. Okay, so remember that. Now let's segue to that irrevocable trust. That irrevocable trust, it's flat. We've taken away the equitable value. You've gifted that equitable value over to that irrevocable trust, okay? Which means you can't have your cake and eat it too. You can't get a home equity line on that property because it's in the irrevocable trust. If you need a new roof, you need a new car, whatever it might be. That property has been conveyed over. Here's the house. It's going into that irrevocable trust. I can't have my cake and eat it too. I can't touch that equity and then say, oh, creditor, take a hike. Can't do it. So that's why one attorney could say one thing and another could say another. But the reason why is because we look at your assets, and perhaps moving your home into an irrevocable trust is not a good product for you because you may need to tap into that equity, okay? So we don't have a crystal ball, right? None of us would be here if we did, right? So we don't know when something's going to happen. We don't know if something's going to happen. Nobody wants to go to a nursing home. We all just want to die in our sleep at night, right? So we have to look at kind of the totality of what's going on to see whether or not it's a good idea for you to put that irrevocable house into an irrevocable trust, because you will lose that equitable value. Does that make sense? Does anyone have any questions on the irrevocable trust?
Is there a limitation?
So people at home can hear you.
Hello? Is there a limitation as to how soon you have to do this before you die?
Questions. These questions. questions, amazing. So let's talk about that dreaded 5-year look-back period, right? Everybody knows about that. Why do we have a look-back period? We have a look-back period because whenever any one of us in this room goes into a nursing home, we're all private pay. They pick our pockets first, okay? You go to the Capitol Grill at Legacy Place, you order a steak and a bottle of wine, they pick your pocket, right? Whenever you get services, you pay for them. So what happens with a nursing home to become qualified, this is where we're going to segue over to this guy over here, we qualify for Mass Health Services. Again, it's formulating and taking into consideration all of your assets as to whether or not you would be qualified to receive services from the state. The 5-year look-back period is because, unfortunately, people took advantage and they would give away property in anticipation of a debt from a nursing home. I give David $20,000, I hand out $10,000, and then I say to the state, hi, I ran out of money. Can you pay for my nursing home care? Well, then the state said, oh, well, let's start looking back and see if people were committing fraudulent conveyances of giving money away in anticipation of a debt. So that's what's looked at. Why do we want your home to be moved to an irrevocable trust before the look-back period? So it's not shown as a countable asset. And by the way, they don't take your house. What happens is when you go to a nursing home, it's like renting an apartment for a month. You pay on the first of the month and you get to stay there till the end. Then the next month, you pay the beginning of the month and you get to stay there till the end of the month. When you run out of money because it's already been picked, that's when they say, oh, you still have that house over there that has equitable value that you were able to touch and use. So make sure you sell it, because if you want to stay, you need to get the proceeds from the sale in order to stay. So nobody comes in and takes anything. The nursing home doesn't. The state doesn't. It's the formula that goes along with it. Yes.
Thank you. So just so I have it clear, if you had $500,000 in assets sitting with Fidelity, right? And I go to a nursing home, first the nursing home would take the $500,000 and then I run out of money and then they come after the house?
Well, then you have to sell the house.
Sell the
in order
house.
to stay there.
Okay.
Yep.
I mean, they don't.
David, would you like to tell us about the formulas?
What Mass Health does, if you have $500,000 and you have a house as well, they're going to want you to spend down your income first. And once you get below the $2,000 limit, they're going to want you to sell your house to get below that limit. However, if you come to an attorney who knows what they're doing, there's a way to manipulate the system where if you are married, you can transfer your interest in the house to your spouse. That's a permissible transfer. So we take that asset out of your name. If you have the $500,000, we can create what's called a Medicaid compliant annuity, and we change that principal into income. So it slows down how much is being paid out to the nursing home. Another option is called the pooled trust, and it's run by the state. It's for a nonprofit, and it's a permissible transfer. We could take that $500,000, put it into the pooled trust. So on paper, you are below the $2,000 asset limit, which makes you eligible for Mass Health, but you can still pull money from the pooled trust at that point. The downside is the state at the end gets paid back from what is left over in the pooled trust, but if there's anything left over, it's still distributed to all your beneficiaries under your will or your trust.
So let's go back to planning, right? Because we don't know when this would happen. So David just gave you all of the options that are available. There's only so much estate planning that we can do, but we want to make sure we do that estate planning. One moment, please.
Can you explain a pour-over will?
Oh, sure. Yep. So very quickly, going back to the will, when you have a trust, you have a trust document and you have your will. This is hard. I'm Italian. I speak with my hands. And you have the will here. And you say, I give my car to my husband and I give my jewelry to so-and-so. Then all the rest, residue, remainder, pours over to my trust. That's what a pour over will is. When you have a will and a trust document, which that's my goal to get everybody to have, it's a pour over will because it pours over your instructions for the distribution to be made according to the trust. Make sense?
I have a question. How does homesteading come into play?
Okay. We'll go back to the irrevocable if anybody has any questions on that. So a homestead is to protect your equity interest in your home when you own the home. If you own the home individually or you own it in a revocable trust. What does that mean to protect your equity interest? It protects your equity interest against involuntary lien holders. A mortgage is a voluntary lien. You said to the bank, hi, I need to borrow money. They said, great, sign this mortgage, which is a lien, and we're going to record it at the Registry of Deeds. You can't be protected from somebody that you had mutual consideration with. This is if you get into a car accident and unfortunately you hurt someone and that person finds you negligent and then they get a judgment against you and they take that judgment and put it against your property at the Registry of Deeds as a lien. The homestead stops them from being able to sell your home to satisfy the debt, but it's twofold. It also, if you decide to sell your house while that lien's out there, you still get to take the proceeds and put it in your pocket. It doesn't go to that lien holder, okay? So we've had an update in the homestead. The homestead, if you claim it, you have to fill it out. You fill the form out. You take it to the Norfolk County Registry of Deeds, and it has to go to record. As long as that's on record, you get $1 million worth of equity protection from an involuntary creditor. Okay? Does that make sense? So everyone should have a homestead. If you own the home in your own individual name, you should have a homestead. If you own a home in the name of a trust, there's another statutory law that you need to claim it under. And if you're an elder, which is 62 and above, you have to claim it under that as well. So there's different statutory sections that you need to claim your homestead under, okay? If you go to the registry, they're very nice and they'll help you do it. But of course, you know, I guess Google can help, but we can help you too. Does that make sense? Okay.
You make it sound like that everybody here is going to run out for an irrevocable trust. Could you also address the tax implications of an irrevocable trust?
Well, I hope they don't all run out and do an irrevocable because, again, it's not always a good product. And I understand the goal to protect, but, you know, if you have to tap in. So the implications, that's a very good point. Thank you for bringing that up because there's pros and cons to everything that we do. So it's important that we get to the cons. So a lot of my clients bought their house in 1968 for $35,000 in Walpole, right? How much is it worth now? 6, 7, 800,000. When you take your property and you are alive and you gift that house to an irrevocable trust, the beneficiaries of that irrevocable trust get that $35,000 basis because when you put it into the trust, you did not get consideration back, fair market value consideration. So those beneficiaries, after the date of death of the person that gifted the house over to the irrevocable trust, those beneficiaries' basis is $35,000. Not to get too complicated, but if there are any improvements made, windows, roof, you can bump up the basis a little bit. But if that house is sold for $700,000, they're going to pay what's called a capital gains tax from that basis up to $700,000. Another reason why it's not always a good product for everybody. Because your intention is to save the house for your kids or for those beneficiaries. However, choice A is you keep it in your own name, And when you die, you get a step up in basis. So, maybe I'll roll the dice and not put it into an irrevocable trust, or put it into an irrevocable trust, and then when I die, my daughters have to pay 20% on $600,000. Okay? So, information's key. We talk about different documents. We need to make sure they're good products for you. We need to make sure that they're accomplishing your goals, and they might, but then it's also important to make sure that if there's any consequences that you understand those, and perhaps the benefit outweighs those consequences. But everyone's different. Everyone has different stuff going on. Thank you for bringing that up. I appreciate it.
Now, David mentioned a few options that you could undertake. One of being I could transfer my interest in the home to my spouse. Now, would that need to be done before the 5 years, or could that does that play into it at all?
So every option that I gave you right there is if we don't make it through the 5. That's Monday morning quarterbacking. It's last minute, you didn't do your planning. There's options where I can still move your assets around to make you eligible for Mass Health and still protect your assets for your spouse. So that can be happen the day before you go into the nursing home, but we wouldn't want to do that beforehand. Ideally, if we had the crystal ball and we could plan, you want to do all this outside the 5-year look-back period. But what I showed to you was ways to do it within the 5-year look-back period to still make you eligible for Mass Health and still protect assets for your spouse.
So timing is important too. But again, we don't know when and if. So the sooner you start, the better. But, you know, things can veer off and go a different direction too.
Why would you put your house in a nominee realty trust versus a revocable trust? What are the
So
benefits
a
of that?
nominee realty trust is a revocable trust. It's just a different type of trust. A lot of developers would use a nominee trust. It's basically like a pass-through so that the beneficial interest isn't on record at the Registry of Deeds, because that schedule of beneficial interest stays separate. Does that sound familiar to you if you've used one? So a nominee trust is a revocable trust. It has an equitable interest to it. Well, the question was whether or not if you put it into a nominee trust, if you still own the house. If you have the beneficial interest, you still do. But that is a separate document. Correct. The schedule of beneficial interest will state who owns a nominee trust. That's correct. Those aren't necessarily used for the estate planning that we're talking about today. Sometimes that's used just for one singular piece of land. Hold on, let me get you on the microphone.
If you use a nominee realty trust, it goes to the schedule of beneficiaries. Do they still get the step up?
Did you sell it to them for consideration, or did you gift it to them?
Haven't done anything, but basically, if you put in a nominee realty trust to that schedule of beneficiaries and it goes to them, and you sell it and it goes to them, do they still get the step up on the money if you're still alive?
So, but did you put the money down and then you made them the beneficiaries?
You own the house, free and clear. You put in a nominee realty trust where they are the schedule of beneficiaries. You sell the house. So you sell the house. Who gets the funds? And then do they get the step up?
So it's a revocable trust. So there is but you sell it to them. It's not looking backwards to your purchase. So you're correct. You've given it to them during your lifetime. So it's a gift. So side comment. We have the ability to gift up to $15 million. Who's up first? Come on. So that's under the federal regulations, right? This year, it's $15 million. During our lifetime, we can gift up to $15 million without incurring a gift tax. But a gift tax return has to be filed. So essentially, you've gifted that house to those people. They get the value as of the date that it was gifted. Well, if they sell it the next day, there's no capital gains. If they sell it for the same amount, if they sell it later on and it went from 800,000 to $1 million, you gave it to them for 800,000, and now it's worth $1 million when they sell it. There's a capital gains there, but if it's their primary principal residence, they get a $250,000 exemption. So there's different, CPA world stuff that goes on. But anything else to that fact pattern? Okay, thank you. So nominee trust is just basically another way to own real estate. Normally, it's just used for real estate. Sometimes developers will use it. Sometimes people will use it for a second home. Sometimes they have a revocable trust like we've been talking about as the schedule of beneficial interest. So it's just another, again, product that could be worthwhile for you to use for your estate plan.
All right, this is very complicated. I have a couple tax questions. Let's say you get an irrevocable trust. Who's responsible for paying your bills, like your taxes, and do you lose your senior circuit breaker credit?
What do you mean, who's responsible for paying your taxes?
Let's say you put your house in an irrevocable trust to your kids, but you're going to continue living there.
Okay, I got you now. I understand what your question is. So usually within the documents, it depends on how the document is drafted and how the attorney drafts it. If I was to put my home into an irrevocable trust, I would be like a tenant. I would pay everything. During my lifetime, I would pay everything in order to stay there. But I'm not getting like a tenancy or possessory interest because I don't want to have that. Remember, I want to give it away. So the person that's living in the home is the one that pays the bills. As far as the senior credit, I can't answer that for you for certain. We're not CPAs, but also that usually changes too, and maybe we can get somebody at the senior center to answer that, but I don't have that answer for you. Right? It's expensive to live here. Yeah, it is. It's expensive. And, we also have somewhat of a housing crisis for seniors because you don't need that $600,000, $700,000, $800,000 split colonial anymore because your kids are gone and you have to figure out where you're going to move to. And we have a lot of new construction. However, they have high values to them. So it is somewhat of a little bit of a crisis going on. We have a question here and then we'll come down back.
In answer to your question, I would think that whatever number of hours that you had put in would be applied to your third and fourth quarter taxes. Even if you've died, that should still apply, I think. I know, but is that what your question was? What will happen? Right. Well, it's like income. I don't know how that would be addressed.
What do you mean when it's no longer your assets? If you sell your house, then you still have that credit, and that will be applied when you sell the house. We've done that before.
No, I'm not talking about that. I'm talking about you're living in the house, you have an irrevocable trust, and you do your taxes, you get to keep your senior circuit breaker credit. You're paying all the bills on the house and the taxes and so forth. So, the senior circuit breaker credit is a help.
So what he's referring to is the ownership of the house has changed. So you lose it then.
Because if it's irrevocable, it's not your...
Right, you lose it.
So that's a consideration.
So those are the pros and cons. Yep, losing dominion and control over a home, but then, working here and getting the tax credit, you might not get it on your property taxes. Yep, that's an excellent point. Thank you. Thank you. David, let me grab Linda first.
This goes back to the Mass Health, and it's always been a burning question for me, and I really haven't done my homework, but is there any evidence, can you maybe know, if you know anything about the you can have $2,000 in your account. Yes, yes, okay. Because I think we should get a raise.
I'm not in charge of that, Linda.
So yes, Mass Health allows an individual, if they're in a nursing home, you're not married, to have $2,000 in assets at that time to your name. So like I was talking about the situations earlier, what I would do if I was working with you is I would make you pour on paper, but maybe still allow you to have income. Or put away your money into a pooled trust where it chips down at the amount lower, so there could be something left over. But as an individual, if you're not married, you can have $2,000. I believe if you're married, you can have $2,000 if you're the institutionalized spouse, and the community spouse can have up to $162,000. So those are the max amounts. But there's ways to hide the money, shield the money, and that's why you come to an attorney who can help you figure out all the avenues for your specific situation to help you for your best situation.
This is going to sound dumb. What if you start off with a revocable trust and then decide you want to go to an irrevocable trust, and then you decide you want to go back?
So you can always change a revocable trust because you can amend it, you can change it. Once you go to an irrevocable trust, it's more complicated to blow it up because what you've done is you've given away the equitable interest. So your beneficiaries that you made under that irrevocable trust, they have to agree to, and I use the word blow it up because that's literally what you're doing. We're going to rip it up and put it in the fire. But they have to agree, but also currently under Massachusetts law, that has to be approved by the court because those beneficiaries are giving up their interest in something, a possessory right in real estate, which is under the Constitution. So it has to be a thoughtful process to put it into an irrevocable trust. That's one of the first questions that I get. Can I change this? I'm like, nope, that's why it's irrevocable. So that's what we have to remember. We have to make sure that it's a good product for you. One of the questions, too, that we usually get, too, about irrevocable trust is, if I own my house on High Street in Walpole, can I sell my house in an irrevocable trust? Can I sell it and then go buy at Pennington Crossing? You can't do it, but the trustee of the trust can do it, okay? Because that trustee has all the powers within that trust to sell that property and use the proceeds from the sale of that house to move to a one-level condominium if that's what you want to do. So you have some options, but you're not in control anymore. And some people don't like that. I know I don't like it. You know, it's you've worked hard and you have this home now and it's your asset. So that's why when we talk about fiduciaries, you're also appointing people that you know that you can trust and that know what your goals are and that you know that they're going to enact them. Okay. Any other questions on that? Yes.
Regarding costs, you haven't talked about that. Let's assume you already have a will, which I do, but what's the difference in cost between setting up a revocable versus irrevocable trust?
So there is a difference in cost, and an irrevocable trust is more complex. So the more complex the documents are, the more time and effort. So it does cost more. I'm not going to quote costs right now because everyone's different. So what we do is when we meet with people and we decide what we're going to do, then we give what's called a flat rate fee. If we talk 5 times or 15 times, or over the years, I still get emails from people. All of that's included, unless we're doing something different or changing. But otherwise, we run on a flat fee basis. Somebody else had a question here.
Thank you, David. You had mentioned that, no, actually, you had mentioned that if we put property into an irrevocable trust, that one byproduct of that is that if we try to get a second mortgage or whatever, that would interfere. What about present lien holders? If I have a mortgage and a home equity line, would they object if I try to put my assets into an irrevocable trust?
So one good thing about us, toot my own horn, huh? I do a lot of real estate. So I do a lot of real estate closing, buyers, seller, and lender rep. when you get a mortgage or a home equity line, which is also a mortgage, you sign a promissory note to the bank. I will pay you $500,000 by this date. Within that promissory note, there's what's called a due on sale clause. And that paragraph says that if you deed your property over to another person or another entity in irrevocable trust, where you have lost control over the equitable value, they can balloon payment that note immediately. Okay? So you cannot move your home into an irrevocable trust if there's a mortgage on it or a home equity line. It's against the law. Now, can you move it into a revocable trust? Yes. We have statutory law and we have case law that allows us, because you still own that underneath value, you haven't given away the equitable interest, and you're just changing the ownership name to avoid probate, you can do that without permission from the lender. Back in the day, we used to have to get permission. We don't need to do that anymore. Make sense?
Won't do you any good as far as Mass Health would still come after you. You wouldn't be able to go into that nursing home if it's an irrevocable trust, correct?
That has nothing to do with the lender, but I'm going to have David answer that question for you.
So are you talking about the houses in an irrevocable trust or a revocable trust?
Revocable.
So no, a revocable trust, because you still maintained an interest in the house, it does not protect you from Mass Health at that point.
Remember, you can't have your cake and eat it too. You know, you can't dip into the equity and then say, oh, creditor, go jump in a lake. I know it sounds simple, but I try to break it down. And that's really the formula. If you have control over something and you can use it, any creditor can get at it. So that's why we have homeowners insurance. You know, let's take the creditor of the nursing home out of the equation. If you get into a car accident, you have homeowners insurance because they have a legal portion of your homeowners insurance to defend that claim against someone else if you happen to be found negligent. Okay, because you have dominion and control over that house. That creditor is going to try to get the equity value in it, and you have homeowners insurance, and you have a declaration of homestead on your house. You're pretty good. You're in a good spot. With a nursing home, if you're asking the state to pay for your care, they want to see what all your assets are first, because you're going to pay through your liquidation of your assets first, and then the state will assist you when you hit that $2,000 threshold. So that's why Mass Health Planning isn't for everyone either. Because some people, the likelihood of them spending down to $2,000 is probably not going to happen. And again, there's all these formulas that are out there, and they're all different for everyone.
Thank you. So this is for instance, I put my house into an irrevocable trust. I'm still alive, and then I have trustees, right?
Yes.
So I have sister, and brother.
Yep. They're all three of them are co-trustees?
Yes.
Okay.
They have equal share, right?
Well, those are beneficiaries.
I see.
If they have interest in the property, those are the beneficiaries that get it upon your death. The people that speak for the trust while you're still alive is called a trustee.
Can you have only one trustee or several?
Well, I would never do several because that's a headache. But you can have multiple co-trustees, yes.
So you could have a trustee and a co-trustee.
Yes, but always remember, whenever you have fiduciaries that are co-trustees, co-personal representatives, those people have to act in unison, okay? They have to act together and they have to act in unison. So if they have a discrepancy in a decision, these documents, and we're going to move on to durable powers of attorney and healthcare proxies in a little bit, these documents don't have black and white referee t-shirt language in there. So you need to make sure if you're picking co's to work together that they're on the same page. Sorry to interrupt you, but continue.
So, under irrevocable, it's probably best to have one trustee and then the others.
And then a successor.
A successor.
Yep.
Because then that one trustee can make the decision while you're alive or once you're dead.
Correct.
Correct?
Yep.
So in the event that you made it all three, say your children,
Yep.
and you have Bobby, Mary, and Susie, and they all love each other now.
But we're all human, and all those ugly characteristics come up
Arguments, and they
during
don't-
death and sickness.
On and on.
Yep.
And then comes the time that they have to make a decision. Where does it go if Bobby and Susie say,
You already created the trust, didn't you?
yes,
And when you were alive and you were capacitated, you had all your capacity, you wrote down where it wants to go, a third, a third, a third, or 40%, 30%, 30%. You already did that during your lifetime. You created the trust. You're the settlor, the grantor. There's different terminologies for the people that create the trust.
but what happens if it's time to sell the house? I'm dead, and the three trustees
They look
say-
to the document. That's the ruling document as to where the distribution will go. You already created that.
Okay.
And that's a key element to a trust. We would never draft a trust without stating where the beneficial interest of whatever's owned within that trust, where it's going to go. That's a key element.
Thank you.
Oh, you're welcome. Anything else on trusts?
Could you explain to me what a balloon loan is?
That's when payments due upon a certain date.
Okay, so I'm in this position during COVID. I didn't work for a year, and I have a certain time period that I'm supposed to pay it back, which is going to be in 2 years. If I can't pay that amount back, it's supposed to go into a balloon loan. I don't understand that.
We can talk about this on the side, but basically what you need to do is make sure that when that balloon date comes, that you have, if you're either able to pay it off, or if not, you have now arranged financing to pay it off. And that can be way of a refinance loan. You go to a bank and you say, it's just like having another mortgage. It's just that it's expired. And you get another refinance. You refinance means you're refinancing the debt. You're taking the equity value, refinancing, and you're then going to pay off that other note.
What I'm interested is does homeowners insurance in any way affect trusts, either type of trust? And if you are the sole owner of the home and you own the home but continue to pay for home insurance, it's not financed, it's owned by you, does that have any effect on either trust that might be selected?
Nope, no effect. And if you have your home in a trust, you want to make sure there's two insured parties under your homeowner's insurance. One, yourself or whoever the trustee of the trust is insured, because that's the person or the trustee that owns the home. So we want to make sure that if the home burns down to the ground, the insurance company pays for that home to be rebuilt. The second person that needs to be insured is the person that owns all the personal possessions inside. So, like you have liability and then you have possession in a homeowner's policy. You want to make sure that those possessory interests, all of the furniture, everything that you have inside, is also insured. But that's not insured, that's not owned by the trust, it's owned by the individual. So whenever we move a home into a trust, we have people update their homeowner's insurance policy to reflect to the trust and also the individuals.
Hi, going back to a scenario that was introduced earlier, in which case somebody failed to create a trust that would protect them from the 5-year look back. There were some things you described that could be done, one of which would be to transfer my interest over to my spouse. But again, if I did that, would the mortgage holder be hit me next month with a balloon payment, Would the
No, because
mortgage get called in?
was your wife already on the house?
If my wife and I owned the house.
Yeah, so
and-
she's already an owner. And quite frankly, if you continue to pay the mortgage, they're not even going to know. So, as part of the planning, when David's giving you these, again, it's estate planning ideas that the government allows us to do under the laws, then we also make an assessment of some other items of what we need to do. Yeah.
Thank you very much.
You're welcome. Okay.
Can you please explain what you can put in a trust and what you cannot put in a trust? Like, can you put a checking account in there? Could you put a savings account in there?
So remember at the beginning we talked about tangible and intangible items. So homes, personal accounts, checking, savings, money market, financial accounts, all of those can go into the name of the trust. Anything that you want to change the ownership name on so it doesn't go through probate, okay? Your jewelry, tangible items still remain in your own personal name, but all of that other intangible stuff, it would end up in probate court, okay? I want to move the direction now, because we're running out of time, to durable powers of attorney, healthcare proxies, and HIPAA authorizations. Thank you for your question about homesteads. We've covered that. So these are the documents that you need sometimes in an emergency. Whether you've become physically or mentally incapacitated, you're alive, and you need someone else to speak for you. So we've been so busy with all of our questions, we haven't been looking at the front of this. So the front of this gives you some of the definitions that we're talking about now, the key documents. A durable power of attorney is where I would appoint David. I am the principal and David is my attorney in fact, to speak for me with respect to, you can think of it like financial matters. If I need, if I've become incapacitated and he knows that I wanted to do some gifting, he could do some gifting through my accounts. Again, this is, you have to have the authority to do it, so these original documents are very important. If I wanted him to make some end of the year stock transactions for me so that I can get some gains or losses, whatever I need when I'm filing my taxes in April, he can step into my shoes and act as my attorney in fact and take care of my everyday things for me under a durable power of attorney. The word durable means even if I lose capacity, he can still act for me. There are many types of powers of attorney. They could be limited, they could be directed. The one that we're talking about is the one that we want to create as part of your estate plan. Healthcare proxy. A lot of people have a healthcare proxy because you fill them out when you go to the doctor. You are appointing a healthcare agent to speak for you with respect to any healthcare decisions that are going to be made. Some people have a verbal conversation with their healthcare agent. Some people like to have things in writing. There's some religions that don't allow blood transfusions. If that's your religion, you can have in there that you don't want a blood transfusion. One of a common thing that is in a healthcare proxy is called a living will declaration. I don't like the name of it because you're not really living. This is if you get into a car accident and they rush you to a hospital. And at that hospital, they put you on machines to make sure your blood keeps flowing so that your organs aren't damaged and they keep working correctly. But then they figure out that the engine of the car, the brain and the body is no longer functioning properly. Do you wish to be kept alive on those extraordinary measures? Okay, so it's called a living will declaration. If you do not wish to be kept alive on extraordinary measures, we have that declaration in your healthcare proxy so that your agent that you've appointed, again, a fiduciary speaking for you, is protected. You know, I always use my sister because she's a little bit more emotional than me, but in my mother's healthcare proxy, it says that she doesn't wish to be kept alive, and I've been appointed the healthcare agent because Karen couldn't make a decision like this. But what that's done is it's protected my mother because her wishes is to not be kept alive on extraordinary measures, and it also protects me because if one of my siblings says, you can't pull the plug on mom, well, this is what she wanted when she signed it in 2026, okay? Another form that we create for you is called a HIPAA authorization. Sometimes information is only good as who's getting it on the other side. So this is like a quickie 2-page form. It allows people to work with insurance companies, rehab facilities, things like that to get things done a little bit quicker. Again, the principal gives the fiduciary the authority to do these certain things. Okay? Any questions on any of those documents?
Does Massachusetts have another form, a small or something?
The most form. We're going to do that one too. I'm going to take this question.
If you have a power of an attorney already, is it best only to have one name assigned as power of attorney, or can you name two people?
So
one to oversee the other?
Yep. So if it's to oversee the other, they're not working as co's because they have to act in unison.
Okay.
And I always tell my clients, I'll draft whatever you want, but I do play devil's advocate and say, are these people going to work cohesively? And if they're not, then I recommend you appoint one and then perhaps have the other as the alternate. Our job is to give you things to think about. And then you know the people, and if you know that they'll work together cohesively, then I say, sure, name them co-healthcare agents. But if there's trepidation, and we already brought up a great point, we're treating this kind of like a business transaction, right? You do this, you get this happens, this happens. But we're not really putting the human element into it. And when there's death and sickness, all those crazy human characteristics come up, even if we don't want them to. Who got treated better than me, and, all that kind of stuff. So it's important to remember the situation that those documents are going to be used, the situation that's going on when those documents are going to be used. And as a side note, we want those documents to be updated also, because the medical and the financial institutions that those documents are given to in order to speak for someone else, they don't like to see ones that are 10, 15 years old. Why? Because there's a presumption that Auntie Susie took niece Alice off, and she takes her durable power of attorney to Walpole Cooperative Bank and wants to take all of Auntie Susie's money out. And they're like, can we use this? I'm like, no, it's 15 years old. More than likely, Auntie Susie already got rid of niece Alice. So the recommended period, it's not statutory, I say is 5 years. The reason why I also say that is because there can be changes in the law that you want to make sure get in those documents. The last form that I want to talk about is a Massachusetts form. It's a bright pink form. People have probably seen it with their own parents, or perhaps you've completed it. It's a form that's completed with your own physician or a parent's physician, and it's basically end-of-life decisions. Do you want to be intubated? Do you want a feeding tube, CPR, things like that? We don't handle those types of things. I'm not medical. We handle the healthcare proxy if you have a specific request of your healthcare agent to do, but it's not situational that if you're in a particular situation. And a lot of people, if you've ever dealt with someone that was terminally ill, it gets taped to the refrigerator door because that's what the protocol is, where people know where to find it. Do they want CPR? Do they want to be resuscitated? Ambulance, fire, police, hospice, everybody goes to the refrigerator to look for that information. So if there's a terminal illness, or you have an elder in your family and you want to make sure that their wishes are procured the way that they want them, that's an important form to complete with their physician. Okay? Anything else today? Whoa. Hold on, I got to get Gloria over here. You've been quiet today, Gloria.
But this is going crazy. So I have an irrevocable trust. My husband and I did probably 20 years ago. I don't even know. He's passed 7 years ago. So I redid my will that, stated things, but still the irrevocable trust is still there. Now, I don't have to do that every 5 years, right? No, because that's irrevocable.
Irrevocable, you cannot change it.
Okay,
So it's, you've made it, signed, sealed, delivered, that's it.
that's, okay. Because that kind of startled me, because this has been going back years, you know.
So the 5-year look-back period is a different conversation. Okay. You've done it so long ago, you don't have to worry about the 5-year look-back period anymore.
Just a quick question on effective dates on some of the things you just mentioned.
Yep.
So I know durable power of attorney, I believe, it's effective immediately, that the person doesn't have to be incapacitated.
That's correct. But the word durable means that it will continue on if they do become incapacitated. Correct.
Right. And then the healthcare proxy, it's usually a physician who determines, okay, this person isn't capable of making their own decisions. Healthcare proxy, you step in.
Yeah, and again, that goes to the liability of the hospital. They want to make sure that if someone's competent and there's a discrepancy in the information they're receiving and the patient does have their capacity, they're instructed to speak with the patient first, then the agent.
Exactly.
Yep.
Now the HIPAA release, when does that become effective?
Immediately.
It is immediately.
Yeah.
Okay.
It's not to make decisions, it's to facilitate.
So who holds that document?
I recommend that everyone holds their own original documents. I don't keep them. A lot of attorneys will keep the original documents. I think that all of my clients should have their original documents, because if something happens on a Saturday night, how are they going to find me? Although people do. You know, I feel as though people should have their original documents with them. And then you tell your fiduciaries, okay, they're in a safe in the basement and the safe is drilled to the floor. Everyone has a preference. I do not particularly like safety deposit box because banks are closed on the weekends. So how do you get into there? And on the note of safety deposit boxes, if you have a safety deposit box and it's you and your spouse, please add a third person, because people forget to update. And if you thankfully make sure that you don't have any assets that go through probate, but somebody has to get into that safety deposit box, guess where we're going? Probate court to get permission to get into that safety deposit box. So if you have a safe deposit box, it's important to make sure you have the appropriate number of people on there that can access it.
Could you talk about a living trust?
A living trust is a revocable trust.
Well, I mean, maybe it's not called a living trust, but you could put someone else's name on the deed for your house, and then it just goes to them when you die. And
okay, so you're talking about a life estate.
Okay, life estate.
Yep, that's okay. So that is correct. That is another way to transfer property outside of probate or outside of a trust. And again, it goes contractually. So my mother gives me her house, but she retains a life estate, which means as long as she's living, she gets to stay there. And upon her death, her life estate expires, and then I'm the beneficiary of that home. And it's within a deed that gets recorded at the Registry of Deeds. Yep.
What happens if they need to go into a nursing home in that situation?
So David, you want to answer that about life estates?
Yeah, so if you transfer a house to your children and you retain a life estate, whether that's with an irrevocable trust or just individually, the reason we don't usually do it for children is because it becomes subject to their creditors at their time. But hypothetically, nothing happens. You go into a nursing home, it's outside the 5-year look-back period, they will put a lien against your life estate. But, as Joanne just said, what happens when you pass? Your life estate is extinguished. So the lien's extinguished. So it is a tool. It's more volatile because you're opening it to your children's creditors or someone else's creditors. But it is a tool that you could use to still have a life interest inside your real estate, but still minimize the impact of mass health at that time.
There's a whole nother conversation of estate recovery. I try to keep it in there's so much more that we could talk about, but estate recovery happens when you have a probate asset. And because, thank you for bringing this up, the life estate goes poof, it's not a probate asset because it has somewhere to go. So when someone dies and they've received services from the state, for instance, 24-hour nursing home care, that's where the state can say, oh, you got $100,000 worth of care from us. So guess what? We're going to file a claim in your probate docket, okay? So long story short, that's another reason why to stay away from probate court. Another reason why to make sure your assets have somewhere to go upon your death, whether they remain in your revocable trust or contractually they go somewhere else.
Could you explain what the memorandum of intention is?
Sure. So within your will, it states, I may have tangible items, jewelry, a portrait, a picture of my dog that I want to give to certain people. And the memorandum of intention says a specific item to a specific person. It's an attachment to your will, but because it's a way to avoid probate on tangible items. Okay, so we're allowed to do that. If it's a tangible item that doesn't have an ownership name, right? You don't have like owner of this table, but you can say, I want to give this table to David, and that memorandum stays with your will. Great question. Thank you. Okay, one more, and then we're going to wrap it up.
Is there an advantage to a trust over specifying beneficiaries for like insurance or investments or
Great question.
assets?
Great question. So within a revocable trust, you've named, let's just use a hypothetical that I put my life insurance policy into my revocable trust and my 2 daughters are the beneficiaries. And I lose my capacity, so I don't have an opportunity to update my revocable trust upon my date of death. And the schedule of beneficial interest, it goes to both of my daughters, and I haven't changed the schedule of beneficial interest. And when I die, one of my daughters had actually predeceased me. Well, that daughter happens to have a child. And if I wanted that share to go to that child, that life insurance policy didn't address it. It's only as good as what that schedule of beneficial interest was made out to. And this goes for investment accounts too, or the 529s. Anything that's going contractually, if there isn't a backup plan mentioned, then, it goes by different ways. But having that life insurance policy get payable to a trust, that sets forth my beneficial interest for the day I die. If both my daughters are alive, if one's not alive, it goes to the other one. If the one that's not alive has a child, then it drops down to that generation. So that's another way that revocable trusts are very helpful. Okay, I'm winded now. How are you guys? Thank you very much for coming. As always, I appreciate it. We always appreciate your support. It's so nice to see everyone. Take care.